It's July 1, 2015, and today marks the end of one of the darkest periods in the judicial system in the state of Florida. And I say that because just yesterday, June 30th, the funding ran out on the foreclosure docket rocket effort that courts all across the state of Florida engaged in. Now, the problem with this effort, and it's been the problem from the beginning, is that it showed very dramatically how the entire judicial system stepped outside of its role of neutrality in treating parties that appear before it with neutrality and with objective legal analysis. And what happened is the court system, rather than deciding its own objectives and rather than being truly independent and functioning as a judicial system that has a job to defend the rights of both parties that appear before them and allow parties that appear before them to enter into a truly neutral system where they could be treated fairly, the judicial system stepped outside that entirely and fell victim to the pressures of the executive and the judicial branch. Nowhere is this more clear in this example of the foreclosure purge than the funding that was used to pay for this court system and this project. Senate Bill 1852 that was passed showed how the money that the banks paid as a result of the crimes, the fraud, the forgery, the abuses that they visited upon the American people that resulted in the national mortgage settlement, resulted likewise in the transfer of $300 million or so to the state of Florida. And then that money that was supposed to be used to, quote, help consumers was used not to help consumers, but was used to fund the judicial system that in turn abused consumers and the citizens of the state of Florida. How do I say that? What's the support for that? Well, the money that you look in that Senate bill and how it was distributed was used to fund senior judges, court staff people, and to buy computer systems. And the language in that bill, every single line virtually, had the statement, expedite foreclosure cases, clear foreclosure cases, move them along more quickly. So what you have here is a direct connection from the crimes, the fraud, the misdeeds of the banks, the national mortgage settlement, that money being given to the executive branch, Pam Bondi, and then the executive branch directing the legislative branch how they are to dispose of cases that appear before them. Now, the expression of that on the ground level has been gross hostility in many cases to those attorneys who took an oath to defend clients and, frankly, defend their constitutional, statutory, and other rights, so that when a consumer attorney steps inside a courtroom doing his or her job to uphold the rights of consumers, we're talking about procedural due process, we're talking about following the rules of evidence, following statutory law. But when an attorney like myself walks into a courtroom to a judge who is supposed to be a neutral arbiter of facts, who's supposed to be a neutral party fleshing out the facts, I'm the enemy. I'm the one that is the target of attacks of the judicial system. Now, we see it dramatically in examples all across the state, and we won't really get into that. But the truth of the matter is that those of us who are out there fighting hard oftentimes find ourselves facing threats of sanctions, pressure, abuse, judges telling us, stop making objections, you're getting in the way, you're taking too much time, you're doing these things. Because what we're doing is doing our job. We're trying to hold banks accountable. We're trying to hold their witnesses accountable when in many cases all they're doing is coming into court and straight up lying. They're lying. They're committing perjury. Why am I saying that? Because they're making statements that just aren't true. They're making statements about what prior servicers did or did not do. They're making statements about what documents may or may not be in court files because a law firm 6-7 years ago and 3 and 4 law firms removed might have done. That's lying. That's committing perjury. Those are making statements that are not based on fact. And yet when a consumer attorney raises those issues and tries to bring that to the attention of the court system, you're treated as the enemy. You are the enemy because by standing in the way of the final judgments that the court systems are duty bound by the legislature, by these projects to enter, we are the ones that are confronting the system. Now, early on in this process, I went up to Tallahassee and met with consumer advocates and attorneys and attempted to provide some amount of balance to the court system and in advocating at the very highest levels in the judicial system and asserting that there should be some balance here, that there should be some kind of moderated treatment of these foreclosure cases, and specifically if the court system wants to focus on flushing all investment properties and rental properties and all those things out of the system quickly but then focus on providing reasonable and thoughtful care for homeowners living in homes and trying to work through things with them, that might be a more moderated and balanced approach. But that was absolutely flat out rejected. That very common sense and I dare say equal treatment of parties before a court system was flat out rejected. Now, in those meetings, it was absolutely clear that the highest levels of the court system had met with obviously legislative leaders and executive staff, and as part of that, undoubtedly part of our opponents in the system. These objectives to clear the cases didn't just come because the executive branch and legislators independently thought this would be a good idea. No, the opponents of consumers, the opponents of those who are defending these cases, I'm talking about the banks and the institutions, clearly had a hand, a very direct hand, in producing this system that developed all across the state. And again, what I found so frustrating in meeting with the court system, it was the way that we were just absolutely flat out rejected. And any attempts to provide any guidance, to have any input into what was happening was just flat out rejected. So what do we have today? 2015, July, the courts did indeed flush hundreds of thousands of foreclosure cases out of the system. We've got final judgments littered all across the state. When you look at the dockets and when you look at the numbers of clearance, you will find that vast numbers of final judgments were entered, but that the majority of these cases, something like 80% of the final judgments that were entered, revert back to plaintiffs or the sales are canceled, and then a very small number of those final judgments that were entered actually go out to third parties. Now, there's a compelling metric here that needs to be paid attention to, and that is divide the amount of money, taxpayer money in dollars, that were funded into the court system for foreclosures by the number of final judgments that result in sales to third parties. And what you're going to find is a gross offset in that metric, a gross offset in the amount of taxpayer dollars that were spent translated into the final judgments entered and given to third parties. And so what that means is that we spent millions, tens of millions of taxpayer dollars in an effort that resulted in transferring property and the rights of individuals back to institutions. Bank of America, Wells, Citi, Chase, who are only the debt collectors and the straw parties acting on behalf of Fannie, Freddie, HUD, and the Federal Housing Finance Administration. These are complex issues, but the expression of those and the reality of what happened during this period is very black and white. What's illustrated now that the funding is run out in our court system, judges on the one side and the clerks on the other side are now scrambling again, is the much larger problem. The larger problem is this. The judicial system and the clerks of court are grossly underfunded and are in fact abused by the legislative and executive branch. Our judges aren't being paid properly, and certainly their staff are not being paid properly. The entire judicial system funded by less than 1% of state budget. And so in an era where the legislative and executive branch are touting tax cuts, they're touting all these gifts that they gave out to their friends, their campaign contributors, we have a court system that suffers now more than ever before. The implications for the rights of individuals, constitutional rights and other rights of individuals, cannot be more dramatic. And again, the disparities are so dramatic. Corporations, campaign contributors, those who actually run and control state government get benefits like never before in this state budget. The judicial system, our judges, the clerk, the staff, the people that should be there protecting liberty and protecting the rights of individuals, suffering like never before. And it's time now for lawyers, individuals, and even judges to start speaking out and in ways that they never have before. That should be the lesson from this difficult period that we just came out of. And now as courts scramble to figure out how they're going to plug budget gaps and how they're going to have hearing times and move things forward, this should provoke a conversation about proper funding for the judicial branch and independence and neutrality out of the judicial branch, and not being forced and pressured and frankly extorted and blackmailed by the legislative and executive branch. That's what the lesson of this bad period is.